Hello everyone. Good morning. Good morning Chitralekha. Good morning Mehul. I hope you're doing fine and you must be in full discourse of your preparations. Good morning Saksham, isn't it? So today this week shall be dedicated to the judgment analysis and for today we have this case of Mohammed Umair alias Umair versus the state government of NCT of Delhi and others. Okay, so good morning Badjas Badadum, good morning everyone whosoever has joined. So today we shall be discussing about this judgment of Mohammed Umair alias Umair versus the state government of NCT of Delhi and others, and this is a criminal petition. Okay, and on the bench was Honorable Mr. Justice Subramaniam Prasad, 12th March 2021. Good morning Soumya, Nikhil, Alamelu, good morning everyone. Okay, so these are the facts of the case. You know, the complainant advised the accused not to dispute with his mother when he was having a disagreement with her. However, the accused began abusing and attacking the complainant and fighting with him. The accused allegedly slapped the complainant, then threatened the complainant and went to his home when the mob gathered around them. The accused allegedly stabbed the complainant in the stomach. The latest instance, according to the MLC doctor, is one of a physical assault with a reported knife wound in the belly. The incident occurred close to the residence address. The complainant has been charged with causing serious injury according to the charge sheet. Bail was later granted to the accused and petitioner. The parties had decided to reconcile their differences after the engagement of their parents and well-wishers. According to the petition, a deed of settlement was also submitted. Okay, now the complainant advised the accused not to dispute with his mother. Actually, there was a dispute between a mother and her son. Okay, in this case, the complainant is the mother and accused is the son. The mother, she told her son, she asked him that he should not dispute with her and he should not argue with her the way he was doing. But the son did not agree and in fact, started abusing and attacking the complainant and fighting with him. The accused allegedly slapped the complainant, then threatened the complainant and went to his home when the mob gathered around them. Okay, the accused began abusing and attacking the complainant and fighting with him. Everybody started abusing and attacking the complainant and fighting with him. That the accused said that I'm going to kill you and I'm going to do you this and I'm going to do you that. The accused allegedly slapped the complainant, and finally what happened, the son slapped his mother and then threatened the complainant and went to his home when the mob gathered around them. Okay, then threatened the complainant and went to his home when the mob gathered around them. The accused allegedly stabbed the complainant in the stomach. The latest instance, according to the MLC doctor, is one of a physical assault with a reported knife wound in the belly. Okay, the latest instance, according to the MLC doctor, was that there was a physical assault with a reported knife wound in the belly. Okay. Finally, what happened, that the son, he stabbed his mother. He stabbed his mother in the stomach. According to the MLC doctor, There was a physical assault with a reported knife wound in the belly. The incident occurred close to the residence address. The complainant has been charged with causing serious injury according to the charge sheet. Okay, the complainant has been charged with causing serious injury according to the charge sheet. Bail was later granted to the accused and petitioner. I mean, there is a typo. There's a typo that this is not complainant. The accused has been charged with causing serious injury according to the charge sheet. Bail was later granted to the accused and or petitioner. The parties had decided to reconcile their differences after the engagement of their parents and well-wishers according to the petition. A deed of settlement was also submitted. Okay. The complainant filed the complaint. She said that she was caused serious injury. On an investigation, it was found that the complainant had, that the complainant was actually physically assaulted by the accused and he had stabbed her in the stomach, and therefore the accused was charged with causing serious injury according to the charge sheet. Okay. Bail was later granted to the accused or petitioner, but subsequently bail was granted to the accused or petitioner. The parties had decided to reconcile their differences after the engagement of their parents and well-wishers according to the petition. A deed of settlement was also submitted. Okay, understood? Have you understood the facts of the case? Have you understood the facts of the case? Okay, Nikhil has not got the facts. I'm saying that there was a dispute between between a mother and her son. Okay, and it was a heated debate. It was a heated argument. In fact, when the complainant is the mother and the son is the accused, when mother asked her son that he should not disagree with her or argue with her this way, he in fact, instead of restraining himself, started abusing her and finally attacked the complainant, attacked his mother. Okay, he slapped his mother, he threatened his mother, and then went to his home. When the mob gathered around them, the accused allegedly stabbed the complainant in the stomach, and the son, he stabbed her mother in the stomach. And according to the report of the doctor, this was a physical assault with a reported knife wound in the belly. Reported knife wound in the belly. When the mother filed the complaint, on an investigation, it was found that it was a serious injury, also corroborated by the report of the doctor. The complainant was charged with causing the accused was charged with causing serious injury. The accused was charged for causing serious injury according to the charge sheet. Bail was later granted to the accused or petitioner. However, when he was arrested or when the complaint was registered against him, bail was later granted to the accused or the petitioner. The parties, in this case, the son is the accused and he is also the petitioner. But what happened subsequently was that the parties had decided to reconcile their differences after the engagement of their parents. Okay, the parties had decided to reconcile their differences after the engagement of their parents and well-wishers according to the petition. A deed of settlement was also submitted. Now Nikhil is asking, Isn't in the first line complainant is to some other person who is saying to accused to not dispute with his mother? Just a second. I'm confused now. Nikhil, the complainant is the mother, perhaps. Just a second, Alamelu. Let me see this. Okay. I got confused. I'm really sorry. Thanks for correcting me, Nikhil and Alamelu. Yes. The complainant is different and mother is different. I got confused with the facts. I'm really sorry for this. The complainant is the other person and the mother is the other person. Right. Thanks for correcting me, Nikhil and Alamelu. So, the complainant, the accused was charged with causing serious injury to the complainant, according to the charge sheet, but bail was later granted to the accused or the petitioner. The parties had decided to reconcile their differences after the engagement of their parents and well-wishers. According to the petition, a deed of settlement was also submitted. Okay. The parties had decided to reconcile their differences after the engagement of their parents and well-wishers. According to the petition, a deed of settlement was also submitted. Now, laws, section 482 CRPC. What does for section 482 CRPC? What does section 482 CRPC says? What is there? What is there under section 482 CRPC? Anybody? Inherent powers of the High Court. Very good, Alamelu. Inherent powers of the High Court. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. Okay. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. Isn't it? That means the High Courts under its inherent powers can pass any order as may be necessary to give effect to any order under this code, whatever order is necessary in the, to prevent the abuse of the process of any court, or otherwise to secure the ends of justice, or otherwise to secure the ends of justice. Okay. Now this is important. Which law, which provision is involved in this case? Section 482 CRPC. Now issues. The question before the court was whether the High Court of Delhi may use its power under section 482 CRPC to quash the FIR on the grounds that the parties had reached an agreement. The question before the court was whether the High Court of Delhi may use its power under section 482 CRPC to quash the FIR on the grounds that the parties had reached an agreement. Have you understood the issue? Can you think that something can be of this kind can be done on the ground that the parties had reached an agreement? You know, the compromise can be reached in civil disputes, and mostly the civil disputes are settled by means of compromise. Mostly the civil disputes are settled through by means of compromise. But what about the criminal proceedings? What about the disputes of criminal nature where parties are in direct conflict with each other only because there was a physical assault and there was a serious injury involved? The accused was already charged with committing serious injuries or grievous hurt. Now, can you please tell me that can a high court, now it's not only about the Delhi High Court, the Delhi High Court framed this issue for itself, but it's a general question for all the high courts, whether the high courts may use their power under section 482 CRPC to quash the FIR on the grounds that the parties had reached an agreement. Exactly, Prableen, very good. We have compoundable and non-compoundable offenses. There are compoundable offenses as well as non-compoundable offenses. Exactly. And also we have compounding under section 320 CRPC. Very good, Bajas Bhagatam. Now there are compoundable offenses also. In cases in offenses which are compoundable, there should be a compromise between the accused and the victim. Okay. And the question before the court was whether the High Court may use its power under section 482 CRPC to quash the FIR on the grounds that the parties had reached an agreement. Okay. Exactly, Prableen. With and without the permission of court under section 320 CRPC. Now, so far as compounding is concerned, what is there under section 320 CRPC? Now let me read section 320, compounding of offenses. The offenses punishable under the sections of IPC specified in the first two columns of the table next following may be compounded by the persons mentioned in the third column of that table. Table section of the Indian Offence Penal Code, person by whom offence applicable may be compounded, okay, with 298, causing hurt 323, 334, criminal trespass, house trespass, criminal breach of trust, adultery, enticing or taking away, 498, section 500, section 501, section 502. Okay, these are the sections which are involved. You know, the section 320 CRPC encompasses within its sweep the all those offenses where it is feasible to compound or settle the dispute by means of by means of a settlement between the disputing parties or between the belligerent parties. Okay, now there are sections of the IPC in which persons by whom offence applicable may be compounded, like 1, 2, 3 insult intended to provoke, for example section 504 criminal intimidation, or section 506 the person intimidated in that case, section 508. Okay, the offenses punishable under the sections of the IPC specified in the first two columns of the table next following may, with the permission of the court before which any prosecution for such offence is pending, be compounded by the persons mentioned in the third column of that table. Okay, the person to whom, for example, hurt, dangerous weapons or means is caused, voluntarily causing grievous hurt, voluntarily causing grievous hurt, hurt on grave and sudden provocation. Okay, now there is a huge list of offenses. You know, this encompasses, or this contains an entire scheme, okay, of doing that. entire scheme of doing that. So this is section 320 CRPC. Okay. Now, the question before the court was whether the High Court may use its power under section 482 CRPC to quash the FIR on the grounds that the parties had reached an agreement. The judgment. Now look at the judgment. The High Court cited the case of State of Rajasthan versus Shambhu Kewat 2013, in which it was noted that the scope of sections 320 and 482 CRPC are both comparable and dissimilar. Okay. State of Rajasthan versus Shambhu Kewat 2013, in which it was noted that the scope of sections 320 and 482 CRPC are both comparable and dissimilar. Compounding and quashing of proceedings on the basis of compromise have parallels and distinctions, and the High Court has the sound discretionary power to quash the criminal process in light of a compromise. Section 320's power is restricted, constrained, and limited, but Section 482's power is immense, unrivaled, and supreme. Now you must have got an idea that when the Delhi High Court was citing the case of a State of Rajasthan versus Shambhu Kewat 2013, it was making a very wise comparison between Section 320 and Section 482 CRPC. We have just talked about Section 320. Section 320 contains the settlement scheme between the victim and the accused in cases of criminal disputes. But Section 482 CRPC does not have any boundaries or limitations written in words. It generally talks about the inherent powers of the High Courts. Section 320 specifically enumerates the sections and in which the compounding of the offenses can take place with or without the permission of the High Court in certain cases in different circumstances. Okay. And if a settlement has to be reached under Section 320 CRPC, it has to be done strictly in consonance with the provisions of Section 320 CRPC or with whatever is written under Section 320 CRPC. But when we talk about Section 482 CRPC, Section 482 is general provision of inherent powers of the High Court, in which it is written that the High Courts are empowered to use their inherent powers to, pass any order which is necessary to prevent the abuse of any process of law or to secure the ends of justice. It may be anything. It may be quashing of the FIR. It may be quashing of the complaint case. It may be recall of documents from a subordinate court. It may be quashing of the criminal proceedings or criminal trial which is going on in any subordinate court. It may be anything. If it is arbitrary, if any criminal trial is arbitrary, or if anything is going arbitrary, then in that case it is unparalleled. Okay, so whatever the powers of the High Courts are contained under Section 482 CRPC, they can be compared with Sections 320 so far as the settlement between the parties is concerned. Sections 320 and 482 CRPC are both comparable and dissimilar. Compounding and quashing of proceedings on the basis of compromise have parallels and distinctions, and the High Court has the sound discretionary power to quash the criminal process in light of a compromise. Section 320's power is restricted, constrained, and limited, but Section 482's power is immense, unrivaled, and supreme. Understood? Restricted, constrained, and limited, but Section 482's power is immense, unrivaled, and supreme. Okay, have you understood? Have you understood why the Delhi High Court has referred or cited the case of the state of Rajasthan versus Shambhu Kewat of 2013 and started, made again a very wise comparison between sections 320 and sections 482 CRPC? Have you understood? Is there anything that you have not understood? Understood or not? Any problem, any question up till here? Understood? Okay. Now let's move ahead. Section 320 of the CRPC limits and guides the criminal court's ability to compound an offense. What does section 320 CRPC does? It simply guides the criminal court's ability to compound an offense. That every criminal court is able enough to compound any offense. It limits and guides the criminal court's ability to compound an offense, isn't it? While the material on record guides the High Court's inherent power to issue an opinion on whether or not to quash a criminal complaint. Even if the eventual outcome is an acquittal or dismissal of an indictment, the exercise of this power is to serve the goals of justice. Okay, Naman is asking, what are the parallels, sir? The parallel means that section 320 and of the CRPC, it talks about the settlement of disputes between the parties in a criminal case. Now listen to me very carefully. Section 320 talks about settlement of disputes between the parties in a criminal case. Okay. Section 482 of the CRPC does not talk about anything specific. It talks about the inherent powers of the High Court. And under the shadow of inherent powers of the High Court and under the shadow of the words written in the section that like High Court is empowered to pass any order, it may, it may also settle the dispute between the disputing parties in a criminal case. So if the High Court intends to establish a settlement between the disputing parties under section 482 CRPC, section 320 and section 482 would then become parallel. Parallel means running together, because section 320 is also talking about settlement and High Court is also using its power under section 482 CRPC to do exactly same what was written under section 320 CRPC. So when this happens, that High Courts, they intend to exercise their powers in the section 482 CRPC to do exactly what is written under section 320, or in fact more than that, then these two sections would run parallel to each other. However, they are not supposed to meet. They are just like the railway lines. They are running parallel to each other. Okay. Whatever is the High Court is intending to do under section 482 CRPC, it is equally competent to do under section 320 CRPC. Okay, that's what in that is exactly the context in which the word parallel has been talked about. Okay, understood? Understood or not? Now, section 320 of the CRPC limits and guides the criminal court's ability to compound an offense, while the material on record guides the High Court's inherent power to issue an opinion on whether or not to quash a criminal complaint. Even if the eventual outcome is an acquittal or dismissal of an indictment, the exercise of this power is to serve the goals of justice. Similarly, now we are talking about another case. Section 320 CRPC is guiding the criminal court's ability to compound an offense, and at the same time it is limiting its powers, because the court has to stay within The boundary is set by section 320, and every single offense mentioned under section 320 CRPC has to be compounded exactly in a way which is written under section 320 CRPC. You know, when section 320 of CRPC is guiding the criminal court's ability to compound an offense, it is at the same time limiting the criminal court's ability to, compound a criminal offense. While the material on record guides the High Court's inherent power to issue an opinion on whether or not to quash a criminal complaint. Material on record guides the High Court's inherent power to issue an opinion on whether or not to quash a criminal complaint. Even if the eventual outcome is an acquittal or dismissal of an indictment, the exercise of this power is to serve the goals of justice. Even if the eventual outcome is an acquittal or dismissal of an indictment, the exercise of this power is to serve the goals of justice. Similarly, in Narinder Singh versus the state of Punjab, now the Delhi High Court was citing another case. After the case of this state of Rajasthan versus Shambhu Kivat 2013, the Delhi High Court was citing another judgment. Another judgment is Narinder Singh versus the state of Punjab 2014. In this case, the Supreme Court decided that the High Court, in exercising its inherent competence under Section 482 of the CRPC, might cancel criminal proceedings in cases of non-compoundable offences. The Gyansingh case was taken into account. It went on to say, however, that the inherent power should be handled with caution. Even if the section 307 offense is serious, the court checks to see if the incorporation of section 307 is for the purpose of the name or if there is sufficient evidence to establish it. Understood? Narinder Singh versus the state of Punjab 2014, the Supreme Court decided that the High Court, in exercising its inherent competence under section 482 of the CRPC, might cancel criminal proceedings in cases of non-compoundable offences. This is what the Supreme Court has said, that if there are criminal proceedings, if criminal proceedings are going on in any trial court, or in case of a non-compoundable offense, like the offense might be very serious. The offense might be the offense of murder, or the offense of grievous hurt or dacoity, or these kinds of things. Then in that case, it may be of culpable homicide. So in that case, section 482 of the CRPC even empowers the High Courts up to an extent to cancel those criminal proceedings in cases of non-compoundable offenses as well. This is how it goes up to that extent. Section 482 CRPC is not just about the quashing of the FIR. Section 482 CRPC is about the inherent powers of the High Court, which the High Court can use to do anything it may feel in the interest of the justice and to prevent the abuse of power or to secure the ends of justice. Isn't it? Understood? So in Narinder Singh versus the state of Punjab 2014, the Supreme Court decided that the High Court, in exercising its inherent competence under section 482 of the CRPC, might cancel criminal proceedings in cases of non-compoundable offences. The Gyansingh case was taken into account. It went on to say, however, that the inherent power should be handled with caution. Even if the section 307 offense is serious, the court checks to see if the incorporation of section 307 is for the purpose of the name or if there is sufficient evidence to establish it. Okay? The Gyansingh case was taken into account. It went on to say, however, that the inherent power should be handled with caution. Even if the section 307 offense is serious, the court checks to see if the incorporation of section 307 is for the purpose of the name or if there is sufficient evidence to establish it. But at the same time, in Gyansingh case, the Supreme Court said that this power of the High Courts under section 482 CRPC is unparalleled. and it's unrivaled, and it's like it's very unlimited. But since it is an unlimited power, it should be used with, you know, great caution. Great caution in the sense that, for example, a case under section 307. What is section 307? It's attempt to murder, and it's a very serious offense. Okay, sometimes what happens that there is a grievous hurt, and that grievous hurt is often taken to be as an attempt to murder, because if somebody is trying to hit the other person and that injury becomes quite grievous and painful, the prosecution tries to build up a case to closely fit it into section 307 of the IPC, to in fact make a case of attempt to murder rather than grievous hurt. Okay, so if, for example, in such cases, I've just given you an illustration when the prosecution tries to, you know, give the accused or tries to implicate the accused under section 307 only for the grievous hurt he has inflicted on the other person or on the victim. This is, you know, these are very close offenses. If you are hitting someone very badly, you might be inflicting grievous hurt, but the prosecution, in order to, you know, in order to put you in hot waters to up to the maximum extent, it might also, you know, will try to implicate you under section 307 of the IPC. And in such a case where the application is filed under section 482 CRPC before the High Court to cancel the criminal proceedings going on under section 307 of the IPC, this exercise of power should be handled with great caution. Even if the section 307's offense is serious, the court should check to see if the incorporation of section 307 is for the purpose of the name, or if there is sufficient evidence to establish it. Okay, or if there is sufficient evidence to establish it. Are you getting my point? Are you getting my point, what I'm trying to say? It should be, you know, the court should be very cautious as well as conscious in exercising this power under section 482 CRPC. That, for example, as per the Gyansingh's case, the Supreme Court said that, for example, if the High Court has received an application under section 482 CRPC to cancel the criminal proceedings going on against the accused under section 307 of the IPC, then the High Court should be very cautious and conscious to cancel those criminal proceedings, and before doing that, it should check whether the incorporation of section 307 is for the purpose of the name, or if there is sufficient evidence to establish it, So this is important. This is very important. Okay, understood. Now, using the case of Gyansingh versus the state of Punjab 2012. Now, this is the case from the year 2012. The High Court was found to have the ability to quash an FIR or complaint based on a compromise struck between the parties under section 482 CRPC. Okay, the Supreme Court said in Gyansingh versus the state of Punjab 2012 that the High Court was found to have the ability to quash an FIR or complaint based on a compromise struck between the parties under section 482 CRPC. Inherent power has no statutory limitations, it said, but it must be utilized in accordance with the guideline engrafted in such power, namely, to protect the interest of justice or to prevent any court's process from being abused. Okay. Section 482 CRPC has no statutory limitations. Inherent power has no statutory limitation, but it must be utilized. उसके ऊपर कोई limitation नहीं है, कोई statutory limitation नहीं है. आप खुलकर हाई कोर्ट को ये बोला है सुप्रीम कोर्ट ने कि आप खुलकर बिना किसी टेंशन के आप इस पावर को एक्सरसाइज कर सकते हैं, ठीक है, बट इट मस्ट बी यूटिलाइज्ड in accordance with the guideline engrafted in such power. बस एक गाइडलाइंस, दो गाइडलाइंस दी हैं इस पावर को एक्सरसाइज करने के लिए. What are those guidelines under section 482 CRPC? Namely, 1. To protect the interest of justice or to prevent any court's process from being abused. ये दो चीजें ध्यान में रखनी है. कोई एक चीज इनमें से अगर पूरी हो रही है, the High Court should exercise its power under section 482 CRPC. लेकिन अगर इन दोनों में से कोई सिचुएशन नहीं है तो हाई कोर्ट पे इस इनहेरेंट पावर को यूज नहीं करना चाहिए. That is what the Supreme Court was trying to say in Gyansingh versus the State of Punjab 2012. Okay, understood? In Gyansingh versus the State of Punjab 2012, the Supreme Court said that the High Courts have the ability to quash an FIR or complaint on a compromise struck between the parties under section 482 CRPC. Inherent power has no statutory limitations, it said, but it must be utilized in accordance with the guidelines engrafted in such power, namely to protect the interest of justice or to prevent any court's process from being abused. Now, have you understood? Have you understood up till here? Any problem? Understood. Okay. Only Baj Jazbato has understood. What about others? Okay. Okay. When the offender, now let's move ahead. When the offender and the victim have settled their dispute, the power to quash the criminal procedure, complaint or FIR may be exercised depends on the facts and circumstances of each instance, and no category can be defined. You know, even when one of the former Chief Justice of India, he occupied the chair of the Chief Justice of India, he said while joining that every case comes with a different face. Every case has a different face. Every case has a different face. A has murdered B. Y has murdered Z. Okay, A has murdered B. Y has murdered Z. Okay, but these two murders might be very different from each other. Okay, perhaps A might be punished for life imprisonment or even might face death penalty, or in fact Y may be acquitted by the court, or Y may face a lesser punishment. Why this happens? Because for a common man, the two cases might be very different. The two cases might be very similar. That is also a case of murder. This is also a case of murder. But for lawyers and for law students like us, these are two very different cases. Because the facts of these two cases are very different. The circumstances of these two cases are very different. The victims are different. The culprits are different. The places of commission of crime, they are different. Okay, the timings are different, the motives are different, the way the murder was committed, the mode of commission of crime is very different. Everything is different. The history of the culprits in the two cases are very different. So every case has its own phase, every case comes with its own phase, and that's what the Supreme Court was trying to say in this paragraph, that every case has its own phase, and whenever the High Court is receiving any application under section 482 CRPC, it has to fix these two guidelines or either of these guidelines in a particular circumstance of a particular case, and try to find out, because we cannot build a concrete standard or parameters for the enforcement or implementation of section 482 CRPC. When the offender and the victim have settled their dispute, the power to quash the criminal procedure, complaint, or FIR may be exercised depends on the facts and circumstances of each instance, and no category can be defined. Okay? Or FIR may be exercised depends on the facts and circumstances of each instance, and no category can be defined. No category can be defined. Understood? Now the court took into account that the accused was a 21-year-old adult with a whole life ahead of him. The court said that 21 साल का लड़का है, he was just 21, और उसके आगे पूरी जिंदगी पड़ी हुई है, and he has no criminal history, and he even did not abscond, भागा भी नहीं वो. Okay, 21 साल का लड़का है, एकदम ग्रेव एंड सडन प्रोवोकेशन में उसने एक ग्रीवियस इंजरी इन्फ्लिक्ट कर दी है कंप्लेनेंट के ऊपर, और 21 साल के लड़के के सामने भी पूरी जिंदगी पड़ी हुई है. ही इज नॉट अ हिस्ट्री शीटर and he has also not absconded. He is facing the trial honestly. So these factors are very important in a criminal trial. In deciding the fate of the accused, the court dwells upon these factors, very consciously, that he is aged this many years, and he has a whole life ahead of him. He has no criminal history, he has not absconded, and it was discovered after reviewing the charge sheet that the complainant slapped the petitioner. As a result, the petitioner was offended and he grabbed a knife from a vegetable vendor and stabbed the complainant in self-defense. Both parties live in the same neighborhood. The suspects have already been in detention for a month. Now, as a result, the court decided to quash the FIR under section 482 because the 21-year-old adult has his whole life ahead of him and the parties had reached an agreement. So therefore, when the parties are reaching an agreement in such cases, the courts can can make that settlement using the high courts can settle such kind of differences using their powers using their power under section 482 CRPC. Okay, understood? Any question, anything that you want to add or you want to ask? Lipsa Chaudhary is asking, sir, if High Court quashes any case, can the complainant appeal in High Court? Yes, the other party is always, it's the option of appeal is always open. Okay, High Court can quash if the High Court has quashed any case, then the other party can make an appeal against it. Okay. Okay. Anything else? Naman is asking, sir, 482 can be used to quash any type of criminal proceedings? Yes, Naman. Any type of criminal proceedings, like compoundable offenses where no settlement is done. Yes. Yes, Naman. The High Courts can exercise their powers under Section 482 CRPC to quash any kind of criminal proceedings where no settlement is reached. If the High Court finds that the criminal proceedings are going on baselessly or arbitrarily, or these criminal proceedings have no legal basis, there is no proper evidence, and if the High Court strongly feels that the accused was wrongly implicated in the case, there might be any reason, the High Court, for any reason, if that reason is actually securing the ends of justice or preventing the abuse of any legal process, then it can do so. Okay. Lipsa Chaudhary says that Supreme Court only entertain cases and questions of law. Exactly, Lipsa. Supreme Court is not a regular court of appeal. You cannot make it a regular court of appeal. But Supreme Court is the appellate court at the end of the day. And it's not that it only entertains cases and question of law. Okay. For example, this is also a question of law, that if the High Court has wrongly quashed the criminal proceedings under Section 482 CRPC or not, or whether those powers were arbitrarily exercised. This also can become a question of law. And if this is a question of law, appeal can be made, Lipsa, isn't it? Yes, Naman. MLA Rana in Maharashtra has also filed the application for quashing of FIR under Section 482 CRPC before the Bombay High Court. That's right. Understood? Any other question? Okay, Lipsa. Thank you. Thank you all then. And Eid Mubarak in advance to all of you. Tomorrow is Eid. Let's celebrate with joy and happiness. And let's meet after Eid. Okay? Till then, bye-bye. And a very good afternoon. Eid Mubarak. Thank you, Taran, Naman, Lipsa. Eid Mubarak to all of you. All of you. Okay? Thank you, Alamelu. Thank you, Baat Jazbaat. Thank you all.